Not every DUI arrest ends in a DUI conviction. Prosecutors, judges, and defense attorneys all play a role in how a case resolves, and the evidence collected at the scene, at the lab, and during the stop itself can all affect the outcome. Understanding the main reasons charges get dismissed or reduced helps you know what questions to ask about your own case. Results vary from case to case. The Fourth Amendment requires police to have a legal reason, called reasonable suspicion, before pulling you over. If the stop lacked that legal basis, evidence gathered afterward, including breath or blood test results, can be challenged through what is called a suppression motion. When key evidence is suppressed, the prosecution may not have enough left to proceed. This is one of the most common routes to a dismissal or reduction. California's Title 17 sets strict rules for how breath and blood tests must be collected, stored, and analyzed. Title 17 is the section of state regulations that governs DUI testing procedures. If an officer skipped the required observation period before a breath test, or if a blood sample was stored improperly, those violations can undermine the reliability of the result. A reading above the legal limit only matters if the test itself was done correctly. Even without a suppression issue, prosecutors need enough reliable evidence to prove every element of a DUI beyond a reasonable doubt. If the field sobriety tests were given on uneven pavement, if the driver had a medical condition that mimics impairment, or if witness accounts conflict, those gaps become relevant. A charge under Vehicle Code 23152, which is California's core DUI statute, requires the state to show actual impairment or a blood alcohol level at or above the legal limit at the time of driving, not just at the time of testing. A reduction means the DUI charge is replaced by a lesser offense through plea negotiation. The most common reduction in California is called a wet reckless, which is reckless driving involving alcohol under Vehicle Code 231035. A wet reckless carries lighter penalties and a shorter probation period than a standard DUI, though it can still count as a prior DUI if you are arrested again within 10 years. Other reductions, like a dry reckless or an exhibition of speed, carry even fewer consequences, but depend heavily on the specific facts and the prosecuting agency. Dismissals and reductions do not happen automatically. They follow from a careful review of the police report, the test records, the dashcam footage, and the legal procedures followed at every step. An attorney's job is to find where the state's evidence falls short and use those gaps in the way the law allows. Every DUI case is built on specific facts, and specific facts can be challenged. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.